So the plan for today is to talk a little bit about the Cambie case, which came out in BC, I guess a few weeks ago now. It doesn't feel like a few weeks, but it's a few weeks ago now. So to sort of summarize that case, some of you are aware that the decision was 880 pages. I think there's probably only a handful of us in Canada who have read all 880 pages. So I'm happy to answer your most technical, minute question that's buried in that judgment, because I'm in a small group of people who's read the whole thing. And then also I'll talk a little bit about what the case means for Alberta, what it means for health policy in Canada, and how it fits in more broadly to some of the moves towards privatization that we're seeing right now in Alberta. So this is the Cambie Surgery Center. You can see a very young Dr. Brian Day standing by the clinic while it's being constructed. As you can see from his sign, it says proof of identification required. BC residents are prohibited from access. And what he was protesting there, or what he was getting at there, was when the clinic first started out. So it's an orthopedic surgery facility. When it first started out, he abided by provincial law at the time, which was that, of course, extra billing wasn't allowed, and we'll talk a little bit more about that later. Private health insurance for publicly insured services weren't allowed. And so when he first opened that clinic and stuck to the letter of the law, what he was providing was things like workers' comp surgeries, and then later the government contracted out some public surgeries to him. But eventually what started to happen was, in spite of the law, he began to privately bill patients for procedures, to bill the government, and then also to collect funds from patients on top of that, so extra billing. And he fully admitted this in the case. His admission in the case was that, yes, he's violating provincial law, but that provincial law is unjustified. So none of that is really contentious. The amount of money he was making from that and how much extra billing he was engaging in, that is certainly up for debate. But the fact that it was going on is fully acknowledged by all of the parties. And so the clinic's been open for several decades. And so it did start out as just a facility doing medical tourism and workers' comp and those sorts of things. On the other side, you can see the BC doctors protesting in front of the clinic as we were leading up to this case. Really, the BC health professionals were instrumental in actually making this case come to a head, in particular the nurses. The BC government knew what was going on to at least some extent for several years, but it was really health professionals that pushed the BC government to do something about this clinic. And once they did, it kind of opened a whole can of worms, because when they pushed the government to take action and to fine him for violating the Provincial Medicare Protection Act, he responded with this constitutional challenge that has been going on for the better part of 10 years, really. I did some work on the expert evidence in this case in 2013. So it's been going on for a long time, but it was really pushed by this desire to have the BC government stop turning a blind eye to some of what was going on. And we see this in many provinces. There are many provinces that are well aware of practices that are probably contrary to the Canada Health Act. Many provinces have private MRI clinics that Health Canada has said violate the Canada Health Act. New Brunswick, the Premier recently said he doesn't care that the province's failure to fund clinic abortions violates the Act. So this is going on across the country, these practices, and I think, you know, maybe it's a lesson for other provinces that if you do get into enforcement activities, you can really find yourself in quite a bit of litigation. So in terms of kind of how the case, what happened in terms of audit and enforcement, one of the important steps that happened was in 2012, the BC government actually did an audit, or attempted to do an audit of Cambie and another entity that refers patients to Cambie. And this audit, they noted that they had trouble getting documents from Cambie and had trouble understanding the exact scope of the billings and the extra billings. But this report concluded that despite limitations on the information made available to us, and they're putting it politely there, we determined that there was significant evidence to indicate that extra billing had occurred both at Cambie and then the specialist referral clinic on a frequent and recurring basis, contrary to the Medicare Protection Act. And so what was happening was patients were coming in, the province was being billed for those patients, and then those patients were being charged a fee on top of that. Eventually, Health Canada got involved, and Health Canada, due to sort of its long history with the provinces, Health Canada has at times taken a more active approach to Canada Health Act enforcement, and then at other times has been more hands-off or has tried to convince provinces to comply. But over the past few years, Health Canada has participated with BC and has pushed BC to disclose some of this information. And what ended up happening is that Health Canada has withheld significant funds at this point from BC for allowing this extra billing to persist. So it's interesting because the relationship is cooperative in terms of the litigation and in terms of the investigation, but of course they have withheld funds. BC does have an opportunity to later get those funds back by fixing these issues. So what Health Canada said is, and this is in the annual Canada Health Act report, they said that following an audit of selected private clinics, which Cambie was the big one, but there were some others, the province submitted a financial statement indicating extra billing and user charges in the amount of $16.2 million. And this information was really pieced together based on patient complaints, audits, and then they had some publicly available evidence of some billings. And so Health Canada withheld that $16.2 million from BC's 2019 health transfer payment. And the previous year they had withheld another $16 or so million. So this has created a bit of a financial motivation for BC to get this under control and to continue to enforce following this litigation. In terms of the actual legal limits in BC on private health care, so these are the legal limits that were being challenged in this case. There are two main issues, and Alberta has really kind of parallel legislation in place. The language is quite a bit different, but the thrust of the legislation is similar. So Section 17 of BC's legislation and Section 9 of Alberta's legislation both get at the issue of extra billing. And so what the crux of those provisions are is that a person, and Alberta specifies a physician or dentist, but a physician that's opted into the public plan, that's part of the public plan, can't charge or collect an additional amount beyond the benefits that they get paid from the public insurance plan. So that's really to get at that extra billing issue. BC is maybe a little more specific in saying that they can't extra bill for the actual procedure or the actual benefit or for the ancillary materials, consultation, procedures, etc. But both of them get at that same issue, which is that extra billing is prohibited, and part of the reason for this prohibition on extra billing is of course it's linked to the Canada Health Act. To get full contributions from the federal government, provinces can't allow that extra billing to go on. So other provinces have very similar rules. And then below, the row below that, Section 45 in BC and Section 26 in Alberta, what that prohibits is contracts of private insurance. And so, of course, you can have private insurance for dental or eye care or services that aren't insured. But what this prohibits is that duplicate private insurance for health services that are covered within the public plan. So what happened in Cambie was when the province came after him, he responded with a constitutional claim. And the constitutional claim says that the combination of long wait times in BC plus those legal limits on private finance from the previous slide, that the combination of those two things, because you have a public monopoly, and he alleges that public monopoly is performing inadequately due to the wait times, that the combination of those two things violates the charter rights to life and security of the person. Now, those charter rights to life and security of the person are not absolute. The wording that the charter uses is that you have the right not to be deprived of those except in accordance with the principles of fundamental justice. So that's kind of a mouthful, but what it means is that you have to show that both the right to life and or the right to security of the person were engaged, and then also you have to show that being deprived of those rights violated the principles of fundamental justice. And to give you an example of a principle of fundamental justice, the one that's discussed the most in this case is the principle that laws can't be arbitrary. So what the court here would ask is, are the government's limits on private finance arbitrary? Does it make sense that the government would limit private finance to protect the public healthcare system? Is there a justification for those laws? Do those laws have a rational basis? And so that's what that weird principle of fundamental justice language gets at. So again, the plaintiff in this case has to both show this violation of his rights, and then that this violation is arbitrary or is unjustified. And as you can imagine, there's a whole huge body of Supreme Court of Canada case law around those principles of fundamental justice. So I'm really kind of boiling them down to their kind of roots. So one of the questions that always gets asked about this case, and I got asked about a dozen times on Twitter, is what about Shaoli? So some of you may be familiar with the Shaoli case. And the Shaoli case was a case that had gone up to the Supreme Court of Canada on that issue of private finance. And so it sounds very similar to Cambie. The issue in Shaoli was whether or not Quebec's prohibition on private insurance for publicly insured services also violated those rights to life and security of the person. So lots of people are saying, well, wasn't Cambie, didn't we know what would happen in Cambie because of what happened in Shaoli? Wasn't it a done deal? And the answer to that is that, well, the Supreme Court of Canada in Shaoli was actually quite divided in terms of what they found. And so in Shaoli, the plaintiffs won, but they won on the basis of Quebec law. So what happened in Shaoli was you had three different sets of judges writing decisions. So you had at the bottom Justice Deschamps, and she decided that Quebec's prohibition on private insurance violated Quebec law. And then the other six were split 3-3 on whether or not Quebec's prohibition on private insurance violated the charter. So in Shaoli, you have the judges split 3-3 on the issue of the charter. And so Brian Day made a lot of the Shaoli case being binding. We also heard Jason Kenney during the debates around Bill 30 talking about Shaoli. But the truth about Shaoli is that it's not determinative. That because you had that one judge deciding on the basis of Quebec law, you actually had the judges split on whether or not the prohibition on private insurance violates the Constitution. And so Shaoli left us up in the air. And actually, in addition to the Day case, there were a bunch of other constitutional cases that were very similar that were filed around the country, just because Shaoli left that door open. So in terms of what the judges decided, really you had them quite polar opposites in terms of how they feel about private healthcare, but then also in terms of what they feel the appropriate role of the courts is in making health policy. So you have the three judges on my left saying that Quebec wants a healthcare system where access is governed by need rather than wealth. To accomplish this, the province seeks to discourage the growth of the private sector, and prohibition on private health insurance is directly related to that desire to promote a needs-based system. What the three judges said there was very much what was picked up on in Cambie, and very similar language was used in Cambie. The other three, though, they had said that while the decision about what type of healthcare system Quebec should have falls to the government, they said we have to make sure, it's our job as the court to make sure that laws comply with the charter. So the three judges on my left, they were very much in favor of deference to government and allowing government room to make health policy choices, while the judges on the right used words around making sure that laws comply with the charter, and making sure that the government was held to that standard if it was going to have a monopoly. The other thing that was interesting that the judges on my right said was that many Western democracies that do not impose a monopoly successfully deliver to their citizens medical services that are superior to or more affordable than the services in Canada. And it's a long decision, but I pulled that quote in particular because I think we see this language all the time. You see people say, well, and you've probably heard your friends say this, well, France or Germany or whatever country, they have private finance and they're doing fine. And I think that the problem there is it's really difficult to take health policies from one jurisdiction and to just plop them into Canada and assume they'll work. The other thing is that, of course, some of those countries have their own health system struggles. For example, France is often cited as an example, but the role for private insurance in France is actually quite limited and is used for things like co-payments, and is not the kind of private insurance that we tend to think about, like as in the US. So, or places like Australia even. So it's kind of concerning that the judges sort of take these other healthcare systems and say they're doing fine, so we should do that too. Of course, there's many other things as well that that play into the fact that some European countries deliver better health outcomes to their citizens that have nothing to do with the healthcare system. In Europe, they have lower rates of, in many countries, they have lower rates of obesity, they have better coverage of pharmaceuticals, they have better integration of social services with health services. And so it's very reductionist to say that, well, these countries have private health insurance, they're fine, so Canada should do it too. This decision of the Supreme Court was subject to a great deal of criticism. And so in Cambie, Justice Steeves really tried to, without, obviously he's bound by the Supreme Court of Canada, but he tried to kind of navigate and to distance himself a little bit in Shaoli, and to say that the Quebec healthcare system in 2005 is different than BC's, and that, you know, we have more evidence now on private healthcare. And he acknowledged that the court in this case was quite divided, and that the decision was criticized for the way they cherry picked from international evidence. He put it more politely than that, but that is what they did. And so lots of people, when Cambie came up, said, what about Shaoli? And so that's the answer. That's the what about Shaoli. So back to Cambie. I pulled that picture at the bottom, by the way, off of Cambie's website. Apparently Cambie has nicer bedding than I have at my own house, which is sort of depressing. That you know, that room looks as nice as my room, but and it's a hospital. But so the maybe it's stock footage, I don't know. But in Cambie, in terms of that right to life and security of the person, Justice Steeves went over the Supreme Court jurisprudence, went over the Shaoli case, went over the evidence, and what he arrived at was, he said that these prohibitions on private health care don't violate the right to life. And in Shaoli, what the court had sort of said was, well, people could die on a wait list, so the right to life is engaged. Justice Steeves was more cautious, and he said, well, look, patients are not dying on wait lists waiting for elective surgery. He just didn't have any evidence that that was happening before him. He said that Cambie doesn't do life-threatening surgeries for life-threatening conditions. He said that if you had a life-threatening situation, you wouldn't be suitable for treatment at Cambie anyway. And so the existence of Cambie is not sort of saving people's lives, which was what they had suggested. And Justice Steeves said that all of the evidence before him actually suggested that when patients face risks to life or limb, that the public system actually does do a reasonably good job of stepping in and providing care. And so he didn't allow that right to life argument to go ahead. He did, however, allow the argument of that BC's laws violate security of the person to go ahead. And specifically what he said was that BC has these prioritization codes and corresponding wait time benchmarks. And he said some people wait beyond those benchmarks. And of course, the same thing happens in Alberta and in other places. There are patients who wait past the benchmarks. And he said that patients who wait past those benchmarks may, in some cases, experience prolonging of pain and suffering. Their physical conditions may deteriorate. And if their physical conditions deteriorate, that increases their risk of having a worse outcome than they might have had they received surgery right away. So what he's acknowledging there is that in some cases, patients are waiting past the benchmarks, and some of those patients are experiencing physical harm, and that's sufficient to kind of trigger that right to security of the person. The other thing he asked, though, was, well, is it actually the law that's causing people to wait past the benchmark or other factors? Because of course we know that some patients wait longer than the benchmark, not because of wait lists, but because they decline to get surgery, or they want to put it off, or they want to wait for a particular surgeon. But what he said in this case was that there's a sufficient causal link between the law and waiting past the benchmark. So in some cases, there was this link between the law limiting private options and patients waiting past that benchmark. So in short, he found that there was a violation of the right to security of the person. As I mentioned before, though, that right is not absolute. That right, we then have to go on and ask, were the government's laws contrary to those principles of fundamental justice? And I mentioned arbitrariness as an example before. So the government's laws can't be arbitrary. The other thing is that the government's laws can't be overbroad. So they can't capture things that aren't problematic. And the argument that was made there was, well, let's say that doctors work all the hours they can work in the public system. Isn't this law overbroad in not then allowing them to spend the rest of their time treating private patients? And then the third argument, or third principle of fundamental justice that the judge looked at, was gross disproportionality. And this is just a principle saying that the benefits of a law have to outweigh the burdens or problems caused by that law. So it's just a proportionality analysis between the benefits and the burdens of the law. So what he said was, looking at these principles, looking at the international evidence, looking at the evidence from BC, he concluded that there was sufficient evidence that private finance would detrimentally affect the public system. Of course, the government is entitled to some deference, and so he doesn't have to find that the evidence is perfect, or that to hold them to a standard of certainty. But he said that there was sufficient evidence that private finance would detrimentally affect the public system. And the specific concerns that he found with private finance, and These are things that I'm sure you've all heard before. He talked about private finance creating or exacerbating inequities because patients who can pay would theoretically have preferential access to treatment. He found a concern with increased demand for health services overall. And so potentially a concern that these private clinics would drive up utilization of health services as opposed to the number of services that are performed now, that the number would be driven up. For example, that if an insurer was willing to pay and a procedure was moderately useful or was on the line of being required, if an insurer was willing to pay for that, that would tend to be something that would be provided. He talked about how private insurance would drive up overall costs, and this can happen in a number of ways. For example, if the private sector pays health professionals more to work there, then the public sector will have to increase wages to compete. The other one that he talked about, and it's the one that we hear all the time, is that the private sector would reduce capacity in the public system due to a diversion of human resources. He did acknowledge, though, that this is a complex question, that certainly doctors have capacity beyond the hours they're allocated in the public system, and that it's not inherently and obviously the case that any privatization will automatically take providers from the public system due to the fact that there is that capacity. So he did acknowledge the complexity in that issue. But he said that ultimately the international evidence did show a pull from providers from the public system to the private system, and a tendency to prefer to spend time in the private system. And then linked to that, he noted an incentive to prioritize private patients. And this could be for a variety of reasons. It could be because the private system tends to pay more. And nowhere is this more dramatic than in the US, where private insurers pay much, much more than Medicaid, and Medicaid beneficiaries actually have trouble finding doctors at times because sometimes doctors have to treat them at a loss, basically. So it's partly a cost issue. The other issue, though, is that the patients in the private sector tend to be less complex cases, and so they can also be more profitable because more of them can be done in a day. Or caps aren't put on the number of patients a day, or your surgical schedule isn't interrupted by emergency cases, and so it's easier to sort of manage your surgical time. So there's a number of reasons. Also, look at how nice the bed linens are in the private sector. I can only imagine how nice the break room is. So there are a variety of incentives that may pull doctors to the private system that he talked about. Although he did acknowledge, again, the complexity of that issue of spare capacity. And that's an issue that we hear all the time being talked about in Alberta and being debated is, well, would increased private delivery actually pull people away from the public system, or do people have some spare capacity? He then finally, and this is a point that he said the evidence was maybe a little more mixed on, but he did acknowledge that there's a concern that if we allow a private system to flourish, that public support would wane for the public system. And so the concern there is if the more wealthy people, more politically influential people all have private insurance, they're not harassing their equivalent of Tyler Shandro on Twitter to maintain a robust public healthcare system because they have access to a private system. So there is some evidence of waning public support for public health care where there are private options. And so those are the concerns. Obviously he discussed this for several hundred pages, but those are really the crux of the concerns that he had, or with striking down BC's limits on private health care. And he felt that these concerns were sufficiently compelling that BC's decision to limit private finance wasn't arbitrary, it wasn't overbroad, and it wasn't grossly disproportionate. In fact, he said that BC's laws were connected to their goal of maintaining a robust public health care system. So I wanted to talk a little bit about the evidence that he used to get to his conclusions. And really there was some really interesting discussion around, I don't know what Justice C's background is, but he really sounds like he has some quantitative expertise in the way that he weighed the persuasiveness of the evidence, the methodology of the evidence. It's really quite a compelling judicial decision. So with regard to Dr. Day's evidence, he was quite critical of the experts on that side. Dr. Day had patients give compelling testimony about waiting for healthcare. So their anecdotal evidence about the personal stories associated with waiting was of course strong. But in terms of their actual empirical evidence about the benefits of private finance, the judge felt that their evidence was quite weak. The government had a whole parade of economists and political scientists from Australia and the UK and Ireland and New Zealand, whereas Dr. Day's argument hinged on really just a few experts. And some of them, there was a concern that they had a financial interest in the clinic. One of the main experts that Dr. Day relied on, and this one is I think particularly relevant in Alberta, is he relied heavily on an individual that works at the Fraser Institute, who's authored some of those reports that I've shown pictures of at the bottom. And so he noted, and I think reasonably so, that the expert's qualifications were limited. He didn't have an academic affiliation. His publications weren't peer-reviewed. His research is mainly problematic surveys. His publications are situated within his free market advocacy perspective. And he said that it's unclear whether any general conclusions can be drawn from this Fraser Institute evidence. And I mean, I think we all make these criticisms. These criticisms are correct, but I think these criticisms are things that we need to hold our own government to the fire on. One of the main bases on which the government is pushing ahead with private delivery is the only evidence they give is this example of the Saskatchewan Surgical Initiative, and some of the main, I hesitate to call them reports because they're skewed so one way, but one of the main reports on that initiative comes from the Fraser Institute, and so the government here is really relying quite heavily on some of that Fraser Institute evidence, which has its biases and its concerns with its methodological rigor, and the government is really relying on those reports quite heavily here, and frequently quotes those experts to the public. And so, and I've done Danielle Smith's radio show a few times, and knowing her listeners, that's exactly what I tell them. I say, well, regardless of your stance on private healthcare, you should be concerned that the government really isn't giving good evidence as to why it's pushing ahead as it is with sending all these procedures to the private sector. So there is a real kind of lack of evidence here. And again, they tend to hang their hat on the Saskatchewan Surgical Initiative as an example of successful private delivery. But of course, it's much more complex than that. Saskatchewan also did a whole bunch of other things to improve wait times, and injected a whole bunch of public funds into wait times. Since then, wait times have crept back up. But the line here that the government gives us is that Saskatchewan is this successful example of private healthcare. And so again, regardless of one's views on private healthcare, I think there is this real concern, just as the judge articulated here, with the evidentiary basis on which the government is implementing some of these policies. And these policies are ones that it is very difficult to get the toothpaste back in the tube on. Once you allow a private system to flourish, it's hard to undo that. The judge was quite critical of Dr. Day's evidence. On the flip side, the judge spent several hundreds of pages going through BC's evidence. And I've alluded to some of what the judge said already, but a couple of takeaways. One of the takeaways that the judge talked about, and again, this is something that we see here all the time in op-eds by the Fraser Institute, by random people on Twitter, and that is this, oh, but what about France? But what about Germany? And the judge here talked a lot about the dangers of drive-by comparisons of different countries' healthcare systems. And this is a huge problem in that case here everywhere, that you can just take the experience of one country and generalize it to Canada. And he went into all of the different countries that he talked about. He went into Australia, New Zealand, he went into UK, or into Ireland, but I've just chosen the UK as an example. And these are some of the very significant differences he pointed out between the British healthcare system and the Canadian one that make that drive-by comparison challenging. And so again, these are just examples. But he said that in the UK, specialists are paid by salary under employment contracts. And that makes it easier to include terms and conditions about where they spend their time. And so in those contracts, the UK actually does use those contracts to attempt to regulate how much time physicians spend in the public system. That to get an NHS contract, you have to spend X amount of time in the public system, and that you can't see private patients when you're on call with the public system. And so they have all of these rules. And so his point is that, you know, if we were doing a drive-by comparison, we could say, well, the UK has a very cost-effective system and they allow private care at the end. But he's saying, well, it's much more complicated than that. They have these employment contracts that we don't have. These employment contracts enable them to regulate where doctors spend their time in a way that we wouldn't necessarily be able to do in Canada. And so he said that makes the comparison difficult. He also noted, based on expert evidence, and this is a quote from one of the experts, that no respectable scholar would attribute the fall in NHS waiting times to any aspect of the private healthcare insurance market. And so this is the Saskatchewan logical fallacy again, where it'd be easy to say, well, look, the UK has privatization and the UK has shorter wait times, but you're all scientists, you know the difference between correlation and causation. But that's what we tend to see people doing when they're talking about the healthcare system. He does the same for various other countries, talking about the differences, talking about the evidence, and he comes to the conclusion at the end of that comparative section that there is evidence here to support the defendant government's argument that the introduction of private healthcare would detrimentally affect BC's public healthcare system. So after weighing the evidence, after acknowledging the differences in healthcare systems to try and avoid doing these drive-by comparisons, his ultimate conclusion, after several hundreds of pages of analysis, is that there is this evidence to suggest that BC has good reason to be concerned. So that's his decision. So what next? First, Dr. Day has said that he is definitely going to appeal this case. I will say that, you know, if you're a judge and you get appointed to the Supreme Court of Canada, it's always an upgrade. But I'll say it's a particular upgrade from BC to go from that concrete bunker to the beautiful Supreme Court of Canada in Ottawa. So he first will have to appeal his case through the BC Court of Appeal. And a panel of judges will hear that appeal. And so we might get multiple decisions from those judges, some agreeing with the trial judge, some not. And then many people think that, Dr. Day apparently has good financial backing. And so some people think that this will go to the Supreme Court of Canada, where again, it'll be heard by a panel of judges. And so we may get multiple decisions. Unlike Shauli, though, there's no out to Quebec law. They will have to decide whether this violates the charter. And so there will be an odd number of judges and they will have to decide this based on the charter. So we'll finally have an answer for the rest of Canada as to whether our provisions that are similar to BC's are constitutional. If I had to bet, and people ask me this all the time, if I had to bet, I think the case, Justice Steeves' decision will stand at the Supreme Court of Canada. Appellate level judges have to be deferential to the factual findings of trial courts. Trial courts are the ones who sit there for years and hear expert evidence. And on appeal, the appeal is really about legal issues. And Justice Steeves really goes to painstaking lengths to set out the factual basis for his findings, He discusses the BC healthcare system at length, the international evidence at length. And so I really don't think there's a lot they can take issue with factually. So if I had to bet, I would bet that this appeal will be denied at the BC courts and certainly at the Supreme Court. But this could take several years. So this may be going on for quite some time yet. So in terms of what this means or what the implications of this decision are, is that as I think you can surmise, limits on private finance are likely constitutional. I use the word likely because, of course, this may be appealed successfully. I also use the word likely because, of course, all provinces have slightly different limits on private finance. Ours are quite similar to BC's, and so I think that it's reasonable to conclude that Alberta is pretty safe in its limits on private finance. The thing about Alberta, though, is that in BC, the government wanted to retain its limits on private finance. We're sort of in the opposite boat, where there's some discussion among the government about getting rid of limits on private finance. And I get asked this all the time, particularly by members of the public, could Alberta just have a private healthcare system, and what about the Canada Health Act? And the answer is that absolutely Alberta could. This decision stands for the proposition that if a province wants to limit private care, it can. The reverse isn't true. If a province doesn't want to limit private finance, this decision doesn't mean they have to. So if a province wanted to get rid of its limits, by a province, we all know who I mean, if a province wanted to get rid of limits on private finance, there's nothing really to stop them. The only thing that might stop them is that they would risk those federal transfer payments under the Canada Health Act. But I think we've seen recently through the Fair Deal panel report and some other things like that, we've seen the government here isn't that keen on conditional federal transfer funds. And if they think that a private healthcare system could be more profitable, they may say, well, keep your money, Health Canada. We're gonna roll ahead with repealing some of these limits. On October 16th/17th, the UCP is having its annual general meeting. And one of the policies that it's voting on is the one that I've included a picture of here. They're actually going to be voting on whether to support the option of a privately funded and privately managed healthcare system. And if you read the text of this document, they're contemplating private insurance, they're contemplating allowing extra billing. So again, this decision doesn't mean they can't do that. This decision means that if they want to limit private care, that they can probably, but it doesn't mean that they have to. And so it's entirely possible that the government could move ahead with this resolution. And so I guess keep your eyes peeled on October 16, 17, 18 to see what happens here, because this could be a huge change. And again, if they open up a private insurance market, it's very difficult to put the toothpaste back in the tube on that one. The other piece of private finance that I wanted to mention is that the other thing that we see going on, obviously if Alberta repeals its rules on extra billing and private insurance, that would be huge. But apart from those kind of huge moves in terms of private finance, we're also seeing smaller moves towards private finance that I think the kind of cumulative effect of these things is to kind of chip away at public health care. And so we have Saskatchewan, who for several years now has been doing private MRIs. They do one private one public one, and this has the government's endorsement. But Health Canada has said that this violates the Canada Health Act, and now Saskatchewan and Health Canada are involved in this sort of argument. And I've seen some evidence that this has not improved MRI wait times in Saskatchewan over the last few years. Just this week, we see a discussion from New Brunswick. The federal government is looking to penalize New Brunswick and has actually withheld funds from New Brunswick because they won't pay for abortions performed outside of hospital in clinics. And the federal government has said that this charging for a medically necessary service violates the Canada Health Act. We also have Quebec, who for years allowed accessory fees, which are basically user fees. And Health Canada pushed on them for doing that. And so we have all of these kind of little pieces of private finance. Another example would be the boutique medical clinics that theoretically charge people for uninsured services, but some people are concerned that they commingle uninsured and insured services in a way that gives subscribers to those clinics better access to insured care. So there's all of these other things going on that, apart from what Alberta may drastically do, these other things kind of chip away at that private finance as well. So the very last thing I wanted to talk about was, and I know you all understand this as people in the industry, but because I constantly have to remind the public of this, I think it's useful to remind you so that when you're talking to the public on this issue, you can also be clear on this. One thing that I think people really don't understand, based on what's happening in Alberta right now, is this difference between private finance and private delivery. And so Alberta has said that they are going to do 30% of surgeries in private clinics. We all saw the expose about the private orthopedic facility in Edmonton. But the thing to remember is that's private delivery, and Cambie was about private finance. I certainly saw a lot on Twitter after the case that tended to conflate the two, or even after that expose about the hospital in Edmonton came out, I saw people talk about private payment. So I think to the extent that you're doing public education activities or public advocacy, that's one thing I think we can all help people understand better. That being said, I think there's some differences to them, but I think some of the same concerns arise. So I think the equity concerns are more exacerbated with private finance, just because if people are able to buy access, that I think is more concerning from an equity perspective than the perhaps more indirect, but perhaps more insidious way that people with more complex medical needs may wait in public hospitals if private delivery ramps up. I also think, though, that the incentive to prefer spending time in the private sector for physicians is less acute with private delivery than with private finance. I think that with private finance, there is much more monetary gain to be had. So I think there's maybe more of a pull with private finance. But that's not to say there's none with private delivery, because with private delivery, if you can do more cases in a day because you don't have caps, then maybe there's some monetary incentive there. I think as well, though, that some of the concerns that Justice Steeves talked about in his decision with private finance are applicable with private delivery. So some of the concerns with quality of care and maybe a concern with providing marginally effective services may be equally great in privately financed facilities as corporately run facilities that are taking public patients. So there may be concerns there. I think there's also concerns in both a private finance and a private delivery system with transparency. The Cambie clinic was really shrouded in financial, not a lot of financial transparency, and we're seeing the same thing with this hospital in Edmonton. A lot of concerns with, well, who's buying the land, and is it a tax receipt, and what is the government paying for, and will we ever see those contracts, and probably not all of them is the answer. So I think that even though what Alberta's doing isn't about private finance yet, I think that some of those same concerns exist. And there's also some concern that private delivery may be a gateway to private finance. So I think we're at a really interesting time in Alberta. I want to very cheekily end with, you have to be a little bit cheeky. I have to end with this quotation, which I know some of you have seen because you've sent it to me on Twitter. But this is a quotation from our Minister of Health back when he was perhaps more more idealistic and younger. And what he said in the University of Calgary school newspaper when he was an undergrad was to take a minute and think what you want from a healthcare system: efficiency, accessibility, fairness, equality. And is a public system or a private system the best way of providing those things? And according to him, it does not take a brain surgeon to figure that out. So if anyone has any burning questions, you can find me. Well, lots of you already find me on Twitter, but you can also find me. My email address is obviously out in the public domain.